Hi, good afternoon. My name is Anna Melandra. I'm the Director of Marketing for Volpe Koenig. We are a full-service intellectual property firm based in Philadelphia. And welcome to our October webinar, First Steps to Portfolio Monetization and Asset Mining. This course has been approved for 1 CLE credit by the Pennsylvania CLE Board. Volpe Koenig will also report your attendance to the online portal. We use a built-in reporting system within the meeting itself to verify your attendance and report it. So please stay on till the end of the webinar, until the end of the program, and you will be issued your certificate of completion upon by email. Now, if you haven't already downloaded the course materials, go ahead and you can look for that in the handouts. You'll find a PDF of today's presentation, as well as an evaluation form. So we ask that you download that form and return it to us. That would be great. So before we dive in, just a couple of housekeeping notes. Everyone, all attendees have joined the webinar in listen-only mode, which means you're muted. But we're looking to make this webinar as interactive as possible. So if you'd like to ask questions of our presenter, go ahead, type the comment into the question field and feel free. We'll take questions throughout the presentation. And if there's time at the end, we'll take questions there as well. So with that, I will now turn over the webinar to our presenters today, Jeff Gablicki and Andy Bushmeyer.
Thank you, Andy. Thank you, Anna, and welcome everybody. Andy and I will be presenting today. Andy Bushmeyer, he's a PhD patent agent with Volpe and Koenig, and he's been with us for 14 years, and his primary areas of practice are licensing, inter partes matters, which includes IPRs and re-exams, and then he does prosecution and, of course, mining. He works with various technologies in the electrical spectrum, including semiconductor, software, wireless, and consumer electronics. My name is Jeffrey Glebicki. I'm a shareholder with Volpe and Koenig. I've been here a whopping 24 years. I also do licensing, inter partes matters, prosecution, and of course mining. And I also do various technologies in the electrical spectrum, including wireless, cloud, artificial intelligence, software, and consumer electronics. I'd also like to thank Isam Osman, who did a lot of the legal research that you'll see in this presentation today. He's a law clerk in the summer, and he's just gone back to college in September. Now, the goals for the presentation today is that we'd like to get you a general explanation of mining, and then an overview of the steps for mining, and then some how-to guidance. And this will get into tips for using your own resources for mining. We took a look at the attendance, and it seems like it's a mixed legal group. There's looks like some people who are like fairly sophisticated in the mining space, and some that are newer to doing portfolio mining. So it's kind of a mix there, but it's generally, because it's a CLE, it's mostly people in the legal space. So a lot of these tips will be like how to kind of maybe screen assets using more legal techniques than versus more like purely technical technique, but we'll get into some of the overview of all of it. And then because it's CLE, we get into some case laws and statutes relating to mining activities. And I'll turn it over to Andy now.
Thanks, Jeff. So just to provide a brief overview of some of the topics we're going to be covering on the rest of the presentation. I'm going to provide you with some overview as for the reasons for why you may want to perform mining and identify assets for both offensive and defensive purposes. The type of assets you may be analyzing, including pending and granting cases, review scope, including targeted and broader scope coverage, review styles, which include doing more of a phased, iterative cursory approach versus a brute force analysis and different levels in between. also discuss some of the specific steps involved in actually performing your analysis to better, identify what the best assets are in a portfolio, and also some tips as far as how you may want to do evidence of use analysis and searching, and how you may be able to leverage internal and external resources to do that. Then we'll get into some tips as well for some of the positive characteristics of most profitable assets in a portfolio, and then also some things that may be red flags that may ding assets within your portfolio that may lead you to want to maybe move on for that one, or put it on the back burner, consider that to be a less likely profitable asset within the portfolio. And a lot of these tips would be more applicable to something done in a more, that has made it to, say, a second phase or a more brute force analysis, that aren't necessarily possible in a quick review, but certainly are worthwhile steps and tips to consider once you have refined your portfolio down to some higher quality assets. And time allowing, we may also then provide some tips for you regarding strategic prosecution with respect to granted assets, where you may want to broaden if you're within the 2-year window an asset, and some tips on international pending prosecution as well. And lastly, even though isn't quite necessarily within the scope of this particular presentation, we'd like to just briefly introduce what ultimately like a final product would look like when you get through your portfolio mining and have identified an asset and evidence of use and so on, and how you put that all together in a claim chart. Next slide, please. So as I said, we're first going to start with the asset identification, and we've already walked through these subtopics, so I think we can just skip to the next slide here. So why mine? There's offensive and defensive reasons for wanting to mine a patent portfolio. On the offensive side, you may want to you're looking to monetize the portfolio. And there are different ways that you can monetize a portfolio. If you want to hold on to those assets, you may be then looking towards licensing the assets with a potential licensee, or in the event that a licensing negotiation does not, if it breaks down, that you may then want to pursue litigation to assert those assets in court, so that you can generate patent royalties off of those assets. But another prong to that would be to sell higher quality assets within the portfolio. And by mining the portfolio, it's good to have right at the tip of your fingers, what are the highest quality assets? And you may analyze those assets and say, if my portfolio, maybe we want to hold on to the highest quality of assets within the portfolio. Maybe a rung down from that would be assets that you would consider selling and making some profit on those, rather than trying to fully assert those or litigate those in court. Or you may have, it's good to have a good handle of all the different grades of qualities of assets, and can select from each of those different levels of assets to sell and make the bundle that you'd be looking to sell more attractive. On the defensive side, having a good handle on your patent portfolio and where your strengths and weaknesses are can better enable you to strike a cross license or counterclaims in the event that a license, another side comes in as trying to have you sign a license with them, or they're asserting patents against you. When you have a strong portfolio, you can quickly identify the strength of your portfolio through the effort of your patent portfolio mining. You may be able to establish a cross license to either defray the costs that they are seeking, or completely negate through a cross license. And again, separately, you could counterclaim or litigate against your portfolio against that the other side, to again help protect yourself against the patent royalties being sought by the other side. And lastly, that having a strong patent portfolio that you can quickly demonstrate the strength of it by having identified what those most profitable patents are, it can create the shield and ward off people from even approaching you when you're able to establish and demonstrate to the other side how strong your portfolio is. Next slide.
One thing I wanted to add was that sometimes you might actually mine another company's patents. If you're involved in a litigation or licensing, sometimes you can do that in lieu of money. They'll give you a patent, and frequently you might want to identify on your own what are their best patents that you might want to get out of a settlement or out of some like licensing deal. And other times it might be that you're new entry to the field and you need patents, but you know this other company might be there. Maybe they're out of your tech. They're not a direct competitor, but they might be friendly to you. That you might be able to find a patent in their portfolio and possibly buy it from them. But you're probably not going to want to reach out to them and ask them to send you patents, because they're just going to try to kind of sell you their garbage, essentially. So you'll want to maybe mine on your own and determine what are the patents you want out of their portfolio, then approach them with an offer.
Thanks, Jeff. So as far as the types of mining, I had briefly introduced that there would be two types of mining. There are your granted assets, and then there are your pending applications. With respect to the granted assets, you want to assess these the claims of the granted assets with respect to current commercial relevance or potentially future bet relevance. And there, you're looking to line up with respect to the commercial relevance. Is there anything currently on the market, or will be soon to be on the market, where you have solid information about the technology in those products, so that you can assess how likely it is that your patents may be infringed by these products of interest. And future bets are ones that align with a likely development path. For example, you may have patents that read on a standard, a technological standard. Those standards tend to be far in advance of the products that actually implement them in the industry. So if you believe that you have a patent that is infringed by a standard, that could be something that would be an excellent patent to identify and map out with respect to the standard, so that when products do implement it, you have that ready to go and you're armed with that asset. On the pending application side, instead of looking at the claims, what you're looking at is what's the subject matter disclosed in the application. And there you want to then take the subject matter that's relevant to the products that you're interested in, and you are looking to then strategically prosecute the patent application so that you can gear those claims as best as possible to either what you know to be the infringing scenario or what you expect to be the infringing scenario in the future bet case. Next slide, please. With respect to scope of review, there are two different scopes generally, a focused or a general review. Focused is the most common. Here what you're doing is you're trying to reduce how many degrees that you need to analyze your portfolio, or how many of the assets within the portfolio you're trying to analyze. So you may identify a technology space or a particular competitor or product of interest. And by doing so, you can quickly reduce maybe an unmanageable number of assets to a more manageable number of assets. And so then that will also then restrict, say, the breadth of expertise that you need as well to analyze the portfolio. You may specifically gear it towards a display technology maybe, or wireless technology, semiconductor technology, or something of that nature. And then you're able to then rely on an expert that may be useful, or an expertise basis that you have internally to analyze from that perspective. The cons, of course, are you may have assets that fall outside of that focus, and then there may be value there that you may be missing. From a general scope, that's where you're going to be analyzing all of the assets in your portfolio, and you're looking for any applicable avenue where you could monetize the application or the patent. So there you're looking for, say you may be looking at a wireless patent, but find that there's something that's more semiconductor fabrication related in the portfolio, and so you're going to try to track that and still identify the relevance even outside of your potential target necessarily. The pro there is, of course, you're not going to be missing value nearly as much as you would perhaps from a focused approach, but the con, of course, is it's going to be a more intensive analysis. It's going to cost you more as far as relying on more experts. You're going to have to be spending more time looking into different fields. Next slide, please. Now, when we start to dig into the different types and styles of review, a brute force style is certainly one approach you can take where you're reviewing all the assets in the portfolio. You have a low risk of missing any value in the portfolio, but on the other hand, this is going to be very expensive. This is going to be something that's most appropriate when you're working with a size of portfolio that best matches your resources. So if you have a great number of resources that you can review the portfolio efficiently, despite it being a large portfolio, then perhaps brute force is for you. But in general, brute force is mostly going to be beneficial or most applicable when you're reviewing a small portfolio, where you can then do a deep dive on all the assets within the portfolio. But typically, the next slide will start to get into what you usually approach a portfolio. And that's going to be with a cursory style review. And here, this is something that I have a great deal of experience with. Jeff absolutely has a great deal of experience with. You're trying to quickly review a portfolio and triage it from some unmanageable number of assets to a much more manageable number of assets. And a review in this style is one that can be as short as 5 minutes to review per asset, where you're just trying to quickly assess the value. You're generally going to be looking at the claims of the asset primarily, reviewing the figures in the asset, maybe identifying certain claim language that is unfamiliar to you and do a quick keyword search to see if the specification can provide more clarity there. And typically the way this works is, I end up having in a large patent portfolio mining exercise a spreadsheet filled with patent numbers, and then you're rating these. You're running down the line and you're reading the claims, and you're trying to put them into different buckets. You could do a 3-point scale, like a yes, maybe, no. Yes, of course, being has a high potential. Maybe it has potential, but there's more investigation needed. You may have to perform another phase of analysis. No, it's unlikely that you're going to find infringement. It's not going to work out for some other legal reason. Maybe you have concerns with respect to some validity concerns and so on. Now, I typically tend to do something that's more along a 5-point scale. And I like a 5-point scale because sometimes you can find when you go through the analysis of the portfolio, you may have fewer, let's say 1 is the best rating on your scale, that you want to review all the 1s and find that the 1s are actually far too few. And then it's nice to be able to then look at the 2s, for example, instead of having a yes and then a maybe, and then all of a sudden you're looking, you've really not filtered out a great deal of the portfolio. You're looking at maybe even more than half that way. So I tend to prefer and gravitate towards a 5-point scale there. And something also when you're doing this sort of cursory analysis, even within 5 minutes, you can sometimes assess quickly and determine, oh, this may be not applicable right now, but it may have some future applicability. And so it may be worth just making that note. That certainly adds value when you may revisit the portfolio. And another one is the other tag, which would be even though you may have a focused type of analysis where you're targeting a particular product or industry, it may be applicable to some other product or industry, and it's worth tagging that up as well. And one last thing is categories. You can do an overall grade, absolutely. You should have an overall grade for your patents to quickly sort them, categorize them, rank them. But within that, I often like to put down a grade with respect to the ability to demonstrate evidence of use, the breadth of the claims, validity, whether you have, the grade reflecting whether you have validity concerns or think you have strong footing, likelihood of use, being if you're not necessarily aware of its infringement, but you expect it is infringed, so a grade there, whether it's whether it's something that maybe is very implementation specific, very unknown or unlikely to be used. And then relevance to the target, of course. Again, if you have a particular target in mind, is this patent directed towards something that is relevant to that target? Next slide. That's where you take that.
And then the overall, when you have big portfolios, such as like the hundreds, the thousands, the 10,000s, that you're probably going to want to do some sort of software or AI type filtering on it. And for example, you would use like filters, like you might want to limit it to like certain patent search classes, certain keywords in the specification. Frequently, you might want to limit the independent claim length, because if the claim is super long, it's really going to be hard to map all those elements of the claims to a product. So you might want to focus more on shorter claims. One thing to focus on, if you have an inventor in the company or in the company's past that was very prestigious, is very well known in the field, that you might want to look at, search on that inventor's name and pull up those patents and give them a higher priority to your search. Of course, forward citations is kind of a common way to look at the patents. Like they're cited in a lot of patents, cite back to this patent as being prior art. And that's a key term, that's a key factor, because it kind of implies that this patent might be fundamental to the technology, as a lot of competitors have cited back to it, and that they might actually be using that technology in their products or services. Then we also have the assignee or original assignee. This would be more for companies that have acquired a lot of companies over the time or acquired portfolios. And that in that case, you might be looking for a certain technology area, and certain of your assignees may apply to that, where other ones might be like totally irrelevant. So you might just want to screen those out. Then with respect to the artificial intelligence, a lot of companies offer various products that they'll take a portfolio of, they'll take a list of 10,000 patents, and somehow they'll come up with a proprietary ranking for them. Usually like a number score, like from 1 to 100. And then you can just take the ones that have a value over 80 and just review those. The pros of kind of this software / AI type mining is that you can identify the key assets with relatively low cost, because it requires very little human intervention. Of course, the cons are it's garbage in, garbage out, that if the filters are bad, or there's a synonym for a keyword, that you could miss like a key asset. So that's kind of the big downside. Typically, you'll go through like a hybrid approach of like these different approaches that Andy and I described. Like a typical one would, for like a bigger portfolio, would be you do a first pass and do like the software filtering. Like if there's tens of thousands of patents, you might do a keyword filtering onto like a certain product, just to filter out the ones that don't apply to that product. And then you would do kind of, if it boils down to maybe from tens of thousands down to maybe a list of 100, then you might do this cursory review, because that's a manageable number for somebody to kind of go through all the assets, do a quick review, go, this one looks like it has relevance, this one is not, kind of the 1 to 5 or the yes, no, maybe that Andy described earlier. And then once you go through that, the ones that would bubble up as maybe the ones or the yeses on the list, that you might do a brute force approach on those. And then if nothing comes out of that brute force kind of analysis of each of those patents, do an in-depth study of, then you might go to like the twos or the maybes to go through there. And then if nothing pans out there, then you might have to do more software filtering, because maybe your filter was just too restrictive on the first go around.
Right, so now we're going to get into, thanks, Jeff. So now we're going to get into some of the particular steps that you may want to perform in your mining exercise. And again, some of these steps here would be, some of them would be applicable to a cursory review. And again, the length of your review may ultimately determine what you can and cannot accomplish within the time allotted. And so some of these analyses or steps may also then be saved for a later phase, when you get down to maybe say more of a brute force review. So we'll get into some of the more specifics here on the next few slides. So first, a prior art search may be a very beneficial exercise to perform. This particular step, of course, would not be one that you could do in a cursory amount of time. So here, this may be something that it would be beneficial for you to front load some costs for an asset that you already consider to be of high potential, and that before you may want to incur the expenses of trying to find evidence of use, putting together a claim chart, asserting the asset. You may want to do a prior art search. That may also be very well applicable to an asset that has a high grade, except for maybe some validity concerns. That's a perfect asset to do a prior art search on. And there, what you are generally looking for is 102 art. You're going to be wanting to focus on an asset that maybe, it doesn't have to say maybe a strict 102, but is a 102 with respect to perhaps what you know to be the advancement or the novel aspect of the claim. You'd always consider that there's always going to be an argument for there being a combinations of references out there that could render obvious your invention in a particular asset, but that's not necessarily, that's always going to be there. So you're not really concerned with that. You're more looking for that smoking gun reference that maybe really captures the, most of the critical elements of a patent. And that's good that if you, to perform this exercise up front, because if you identify a problematic art, that maybe then, will help you avoid costs on the back end. Next slide, please. Another type of analysis you'd want to do, and again, one you can't necessarily fit into a very short review, but I would prioritize as one of the first types of analysis you do, is a file history review or review of the foreign prosecution. And there, you're looking for file history estoppel. Were there claim amendments made with respect to the closest prior art identified by the examining patent office, or arguments made or amendments made to overcome those that closest identified prior art, so that you have a good handle on how your claims must be construed and what they can not be construed to cover. And that's where the prosecution history estoppel precludes a patentee from regaining through litigation coverage of subject matter relinquished during prosecution of the application for the patent. So you may have said that this prior art reference teaches X, I do not claim X, I claim Y, and thus when you go to construe the scope of the claims, when you're going to assert them, you cannot then recapture that X subject matter. You must stick to Y. And so that the file history review and foreign prosecution review, where you may be prosecuting, or where claims very similar claims may have been prosecuted in a foreign jurisdiction, they may be they may shed a lot of light on the value of your asset, for example, like in the US.
Yeah, and as Andy mentioned before, for the file history review, this is something that you probably wouldn't do in like a normal mining situation. This would be something you'd only probably do if a key asset was identified. And one other point to note is for like foreign prosecution, that you frequently, it's something you wouldn't do on like a very cursory review, but you might want to look, if you find like a claim in like a US prosecution that looks really promising, to at least take a glimpse into like the European and other prosecutions, because frequently you'll see a very broad claim was allowed in the US, and then you'll look in the European prosecution, and then you'll see that it was abandoned frequently. And then you'll look through the file wrapper in Europe, and then you'll see that a search report came up on a claim that's similar to what was granted in the US, and you'll just find like there's a bunch of X novelty destroying references in there. So you probably want to put that asset aside if that's the case, because then you're going to have to really dive into that prior art to see if it actually was a good rejection, and that your US claim is now vulnerable to that. One thing to just keep in mind, this doesn't directly go to mining, is Rule 11 and discoverability of kind of the components, especially in the consumer electronics, where it's a lot of a black box type of review. And, you know, although Rule 11 in practice, you know, you really get a sanction under Rule 11. There's really, the courts are fairly lenient with respect to Rule 11, but you don't want to be the exception that makes the rule and have kind of a more egregious case. But essentially, you're representing that you have or likely to have evidentiary support for it. So you generally don't want to be like doing a fishing expedition where there's a black box and you're kind of just guessing and hoping to make your infringement argument in the litigation. You know, I mean, obviously you could be sanctioned if it's very egregious. And if your case is really weak, you know, again, rarely are attorney's fees given to a party, but if it's really egregious, you might have to pay the other side's attorney's fees. One thing to be cautious of is that I've seen this a number of times where your technical people will tell you, well, this is the way it has to be done, or there's no way they could do it another way. And I've heard that a lot of times. And then when you actually when the foot hits the pedal, that you find out that there was a way to design around it, and there was technical reason to do that. So you can get smoked if you kind of like just rely on your technical people. Sometimes you're going to have to, but if you can avoid that and do kind of like the teardown testing or whatever you need to show it, that would be better. And then there's always the risk that even if you're not filing the litigation, the other side will file a DJ, declaratory judgment, and then you're going to be forced to put forth either infringement argument or try to get out of the case somehow. And in that case, you're going to be forced into a litigation and you're going to have to kind of make your case. Another thing to keep in mind is the duty to disclose, that if you're if you do a prior art search or come up with art and licensing for an asset, that if you've opened prosecution, you have a duty to disclose that. So make sure you provide that to the patent office, and that's going to most likely cover mining activities as well. So these wouldn't be exempt from the duty to disclose. So if something comes up in mining that's relevant prior art for an asset in the portfolio, that you're going to have to disclose it if there's open prosecution. Fortunately, this doesn't generally apply to overseas. Now, in claim construction, the patent office uses the broadest reasonable interpretation standard, but for, obviously for IPRs now and in litigation, you're going to be using the Phillips construction, which essentially boils down to the claim language with the intrinsic evidence, which is mostly going to be the specification and the file history, not the extrinsic like the prior art references and other technical documents. And one key note here is when you're mining, if you look through the claim and you see certain terms that you know are going to be an issue, one thing I'll frequently do is pull up the patent spec itself and then just do a keyword search for that term to make sure first that it's used in the spec. And if it's not, you might want to put that on the side, make it lower priority for mining, because then that term's probably going to have to be construed. And then if it is in the spec, to see how it's defined and just make sure it's consistent with the read that you want to give to that claim term. And then another area to be concerned about is divided infringement, especially nowadays, especially with software and with the cloud out there, that, for example, you have an application on your phone, and then it's going to go through like mine, it's going to go through a ISP like T-Mobile, then go up to a cloud provider, and then operation is going to occur on the cloud and then come back to the phone. That you're going to have a lot of divided infringement potential scenarios. Generally, you want to put these aside. Obviously, if your company's business is being cloud distributed processing type company, you're not going to avoid these, and you're just going to have to kind of deal with the divided infringement issues. Generally here, you're looking for a single entity that controls the act. So if the application's produced by a company and then all the cloud software is produced by that company, you're going to be in pretty good shape. But if the app's owned by the company, but the cloud's just using routine mechanisms by the cloud provider that can you still hear me?
Yes.
Oh, okay.
Yeah, Jeff, your slide hasn't updated.
Okay. Thanks. Yeah, since I lost my connection. But essentially, that if you're that if all of it's kind of controlled by one entity, you're generally in good shape. But if it's not, if people are going to try to pick this apart. So if one part is not performed by you, they're going to say it's divided, and therefore it's not a single entity. In that case, you're going to have to look to a single infringer, such it might be the end user, and you might have to argue an inducement type argument with that user, or some other sort of indirect infringement type type analysis. And then attorney-client privilege. This is it's
Jeff,
just
I'm
important
sorry.
that mining activities.
Your slides
you
aren't
want to
updating,
keep.
Jeff?
They're not updating.
They're not on my end.
Yeah, I flipped to the attorney-client privilege slide. I'm sorry if it's not updating.
Still stuck on the claim construction slide from 2 ago.
Yeah, let me turn it off and then turn it back on and see if that works. Let me
see if I can. Oh, okay.
Now I see.
Is it working now?
Now it is updating, yes.
Okay. Sorry about that. The problems of remote work. The attorney-client privilege, you just want the money activities, you want to keep this under attorney-client privilege because you don't want somebody to come out and with some comments saying, well, this is ranked a 4, and then it becomes like they messed up in the first go around and now it's your #1 asset. So essentially, you want all communications to be marked with attorney-client privilege. Preferably you'll have on all communications, especially if there's going to be like engineer or technical person to technical person type communications, you want like at least an attorney CC'd on it to keep that privilege on there, and you want it all marked attorney-client privilege just so that it doesn't get, inadvertently produced, just slip because it looks like two engineers are talking to each other, so it gets produced versus where it was really involved in mining activity. You just want to keep these all marked attorney-client privilege, and then also just keep an attorney on all the communications, at least as a CC, because you'll be working under the direction of that attorney. Expert sources, the internal ones obviously are going to be the least, at least out-of-pocket cost for most companies. And then you might have technical experts, and that would be obviously your first line. Then they may have current and they have past knowledge of the industry, so they're probably going to be your best resource. One thing to be just hesitant of is that if they came from another company, they might have, secret information, confidential business information, trade secrets, so that you'll want to just make sure you're not using them, because if it ever comes out that an employee came from company X and then they were the ones who did the mining and came up with your infringement position against company X, it's not going to look good, and you're probably, it could undermine your whole case there. So just be careful about that. Obviously, another important resource is the businesses and the salespeople. They know what markets are in the product. They know what the biggest sellers are, so they can kind of, if there's thousands of products out there, but they know 80% of the sales come out of 2 products, you can just focus your analysis on that, so they can be of huge value. And then, of course, this presentation is geared towards like the legal side, where the legal group, they can screen for legal issues. You can possibly use like law clerks to screen for certain kind of more simpler issues, not maybe the complex ones, but they can kind of filter out assets. And then you might be fortunate enough that maybe in your legal group you have somebody who has like a lot of familiarity with the technology. Maybe they came up through the ranks through the company, came from the production side, or is now maybe a patent agent or now a patent attorney, that you might get lucky and have like the one-stop shopping where they can do both the legal and the technical analysis. Or they might just be able to do the technical analysis for you. Then you could do kind of like the high-level legal analysis on it. And then you have other experts where you have your subject matter experts. These are more like you hire somebody like an expert, and then they review the portfolio. This would be different than typically from like a litigation testifying expert. Usually for them, you want somebody with huge credential, like a PhD, 20 years at Stanford, something as a professor, those type of credentials. For this, you probably want more somebody on like the lines of a development engineer versus a college professor, because the development engineer is actually going to know what's in the products and how they work more so than a college professor is going to know more of like the big picture of how it works. The pros of the technical experts is that they'll have very good knowledge of the subject matter. The big con is that they usually have a high hourly rate, usually in the scales of hundreds of dollars an hour, maybe 100, maybe 2, maybe more. So if you're looking at a lot of products they have to analyze, it's just multiplying that rate by the number of products they have to review, going through white papers, technical specs. It's just probably not going to be cost efficient. So you have to look to one of the other alternatives. They're obviously going to lack legal knowledge, and sometimes they're kind of sophisticated and they might know it, but like a lot of times we like use technical experts, and they focus more on the drawings and miss issues that are in the claims, where they'll say like, oh, this drawing looks just like the product, but there's something in the claim that's like way out there, and you just go, yeah, this doesn't work. So you have those issues, and they're technical experts in a certain subject matter. So if you're looking for areas outside of their subject matter, they just might miss it. Like if somebody a Koenig expert, they might miss a patent that actually.
Jeff, I think we lost your audio.
Yeah. Jeff, we've lost your audio.
To be offshore companies, like a lot are based in India, but there's some domestic as well that will develop evidence of use charts. They can go through a portfolio, kind of pull out the key assets for you. The pros of these, like the offshore, is typically the cost. Usually in like India, the costs tend to be much lower, so they can kind of do a lot of grinding through a lot of like technical specs, a lot of white papers, and do the work. The cons are that they lack legal knowledge, and then there's a lot of different variability in the quality. Some are good, some are bad, some are in the middle. So you just have to kind of do your due diligence beforehand. And then they're better on extensive EOU searches, where it requires a lot of white paper searching, technical spec searching, and sometimes even cases where there's very complex technology, if they go through like a lot of source code or something to come up with it. So they might be better sourcing, having a technical expert kind of grind through a huge amount of source code.
Thanks, Jeff. So now I'm just going to get into some of the tips for asset review. And again, these are ones where the tips are sometimes applicable to a first phase or a deeper dive review of an asset. So including detectability, you're going to want to consider certainly ultimately what your damages model is going to look like. Related to that, putting the target on notice, we'll provide some details there. And then some considerations with respect to validity, standards obligations, prior licenses, being aware of the open source software and whether you are potentially already have a license, someone has already a license to the patent through an open source software license, and then also touch on some means claims or nonce words limitations. Next slide, please. So with respect to detectability, the bottom line is you're going to need to demonstrate infringement of your patent. And so you must demonstrate by a preponderance of evidence that is more likely than not that what the target has done is made, used, or sold, or imported, or offered for sale within the United States a product that meets all the requirements of your claim. So what you're going to, when you're looking at an asset, you want to try to assess, and this is something that can be done more on a quick review. Does this asset disclose something that is perhaps inside a black box? Or is this a low-level feature that may be only observable or detected through intense reverse engineering? Is this some low-level circuit design within an integrated circuit? Is it an intermediate computation result where the observant, including these intermediate computations, you'd only be able to observe those through some significant reverse engineering or decompiling of source code, and that would make this exceedingly difficult for you to show evidence of all of the elements in the claim being implemented. So detectability is is very important, and one sort of mated idea to that is just demonstrating evidence of use. You want to at least have some sort of handle on whether, if this is a concept that won't be directly observable to, through just say easy testing, or is something outside of a black box, is it something that you expect to find in literature? Is it a feature that would be more well documented, maybe a feature that is advertised by the particular competitor? That may be something that you are, that you'd rather target, as opposed to, again, something that you would expect to find within a black box. Next slide, please. I think we may have lost Jeff. I apologize. I don't have control of the slides.
Okay, I think we may have lost Jeff. Let's see. Our apologies. Andy, can you see the handouts pane? Because you can pull up the slides in the handouts pane.
I am pulling up the slides right now.
Okay, Jeff seems to be having some issues. Meanwhile, if anyone has any questions, go ahead and put them into the question pane, and our presenters will be happy to take.
Which letter you want, Andy?
Are you back? Okay. I apologize. Just I should be. Yeah, you should be on 26. Thanks, Jeff.
Okay.
And Jeff, we're not seeing your camera.
Yeah, I turned it off to keep the bandwidth down.
So another thing that you want to consider as a tip is, again, keep in mind that ultimately your damages picture. And with respect to that, you should analyze the priority, and then what goes hand in hand with that, the expiration dates associated with your asset. So, if you have an asset that only has a year left of patent term, it may not even be worth performing any further analysis on that patent, because you ultimately, by the time you get through all of your mining, your review of the asset, the evidence of use searching, putting together the claim chart, asserting the asset, you may run out of patent term and then ultimately have no damages from when you put the target on notice. So certainly a very simple thing to keep in mind is the expiration dates associated with your assets. The ones with longer life on them are going to be the ones that are ultimately going to potentially provide more value for you in royalties.
Andy, we have a question.
Sure.
And I guess it's for either of you. For U.S. assets where parallel EP prosecution resulted in an abandonment or narrower claims in general, and understanding that it will be a case specific, would you typically be more inclined to try to argue that the legal standard is different in that jurisdiction, or would you typically be more inclined to just drop the asset?
From a mining perspective, I would put it aside, but I'm assuming that you're suggesting that it's you maybe already put together a chart and all that. I would try to argue it's a different standard, but I would obviously want to take, it's going to depend on if it really is a novelty destroying and there's no argument around it. But I would generally, because you just get different impressions between the US examiners, the European examiners, the Japanese examiners. They all have different opinions, and what one might see as novelty destroying, the other one would not, and likely you just have to make your own kind of assessment yourself.
Yeah, absolutely. Again, in that early patent mining stage, it would be one that would ding the validity grade, for example, which would lower your overall grade, and then maybe put it on the back burner. But certainly if you're further along in the analysis and you've already identified evidence of use and so on, then I would proceed as Jeff suggested.
All right.
And one thing, okay. Is there another question, Anna?
No, I was going to say, I was going to ask the person let us know if that answered your question, but go ahead.
Okay. Yeah, and I was just going to add to what Andy said here, that the ones that are near end of term, it might actually be the opposite, because if you have a lot of key assets that might be near end of term, you might actually want to prioritize and do a brute force review on them, because you don't have much time to get monetary value out of them. So you might want to get them reviewed right away and know if you're going to have to, put people on notice right away. So you might have to actually expedite them if they're near end of term. But normally, if you don't have that feeling, you would probably put them aside, knowing that you're probably not going to be able to enforce them.
Okay, they say yes, thank you.
Okay, and then also something you want to consider in your damages model is the smallest saleable unit concept, which is it's generally required that royalties be based not on the entire product, but instead on the smallest saleable patent practicing unit. And what really this means is you may have a patent with a claim, for example, that read on a larger electronic device composed of many smaller subcomponents, and one of the smaller subcomponents performs all of the features, all of the elements of the claim. Then the smallest saleable patent practicing unit in that case would be just that subcomponent. And so instead of you calculating damages, let's say that component was a phone that cost $1,000, and you found that just the baseband processor within the phone that goes for, in the tens of dollars was the infringing element, then your damages are going to be based on, the tens of dollars per, and then infringement of that tens of dollars component per sale or per product, as opposed to like the $1,000 phone. So that could have a big impact on ultimately your damages model.
Okay, I'll try to pick up the pace a bit because I see we're short on time here. But notice, Andy kind of touched on this previously, but essentially for damages to accrue, the other party has to be on notice. If you have a product and it's being marked, it's going to be the notice is going to be from where the product is marked. But if it's not marked, which is frequently the case, you're going to have to put them on, marking is considered constructive notice, but you're going to have to put them on actual notice if it's not marked, and that'll be more like the letter saying these patents apply to these products. There's a little bit more specificity in that, but that can be looked into. One possible exception to that would be method claims. So if you have these near end of life patents, you might want to be looking at the method claims where you don't necessarily have to have this marking requirement back, but it's not going to be a slam dunk. So you might want to put, if they don't have method claims, you might want to put them aside, and even if they do, you might want to consider putting them aside for a mining exercise. Alice, this is something to consider, especially like in the software space, that essentially Alice was decided in 2014, and you'll frequently see software patents with very broad claims before 2014. If your business is in software, you might want to put those aside just because the patent office does not give before 2014, this case law didn't exist. So essentially, you could get crazy broad claims prior to them, and they would be invalidated today. Essentially, the Alice test boils down to, in more of the software space, is whether it's an abstract concept, and if it is an abstract concept, does it add more to that? Technically, like the safe area would be if it's an improvement on technology itself, but if the claim has stuff in it like billing or invoicing or something that sounds very businessy, you might just want to put that aside, especially if it's before a 2014 date, because it's going to get this 101 type analysis. And then the standard obligations, if your company is involved with the standard, or the company that you acquired the patents from was involved with standards organizations, you could get these obligations, FRAND and other obligations. There's some standards that actually, if you're involved with them, that you have to give everybody a free license that practices the standard. So that would obviously be a big problem, and there's no real sense of mapping a patent with claims that you're going to have to give a free license to anybody using them. But even for other standards, that's the fair, reasonable, non-discriminatory type contribution, that standards requirement obligation would be that the concern there is that although it's difficult enough in patent cases to get an injunction, that with a FRAND in particular, it's going to be hard to argue that the injunctive, like number 2, the remedies available in law, such as monetary damages, are inadequate. It's going to be really hard to make that argument and make an injunction stick. I mean, there could be some egregious cases where it might work, but generally it's going to be really hard to make the FRAND get an injunction on a case that you're obligated to use FRAND.
And just to piggyback onto what Jeff was saying, that you want to evaluate a patent, for example, that has a prior license. It could have a prior license through being licensed through the standard obligations that Jeff had references, or for example, through patent exhaustion. A component may have been licensed, for example, a processor within a computer that was then assembled by a next business down the line, and then that computer may be sold then, and then you can't then take and assert the same patent that was licensed to the processor and then assert it against the computer that is incorporating that processor, because the component within it is already licensed. So certainly you want to make sure that when you're reviewing assets, you're aware of any prior licenses that could be involved, because then you could be facing patent exhaustion that would prevent you then from seeking further royalties on that patent when already licensed in a particular product of interest. And another aspect, again, related to your potential licenses, is you should do an analysis, specifically if you're certainly working with software patents, is to investigate and confirm whether the invention was incorporated or derived from an open source software, and could be then liable or subject to an open source software license. And the term there is copyleft, and copyleft is just, and the most popular example of one is the GPL, the license offered for the GNU open source operating system, where copyleft is general method for making a program free and requiring all modified and extended versions of the program to be free as well. So again, if you derived or created or generated some improvement, your invention was a software invention that improved on the open source software, if you've been derived from that, and then you would be essentially infected, your invention, and thus the patent would be infected by this open source license, so that you would not be able to then assert that patent directed to that particular invention against anyone else.
And one thing in the mining to look into is is that you'll see, especially from the old days, you'll see a lot of means claims. And generally, from a mining standpoint, my general rule would be If you see a means claims, you want to make that a lower priority. You also have nonce words that could be construed as means claims. I would consider them, but I'll go into more detail on that later. But the concern with the means claim is that you get the 112, currently F used to be 112.6, where essentially the means claims are read with the recital of the structure, material, or acts in support thereof, and such claims shall be construed to cover the corresponding structure, materials, or acts described in the specification, the equivalence thereof. Essentially, if you have a means claim, it's going to have to be construed, and then they're going to look into the specification, and then the kind of the construction of the means is going to be like a real crapshoot. And then to make it even tougher, if they can't find the structure, your claim could be invalidated, and then if it's considered that there's one means in the claim, that's frequently a case that'll invalidate a claim. So generally for the means, you want to avoid the nonce words. From a mining standpoint, I generally wouldn't avoid them unless you have a lot of structural patents, then maybe you can have the benefit of skipping those. And then the nonce words are essentially words that are just considered placeholders, like in the Williamson case showed here, with the term module here was construed to be means, and then forgot the 112.6 construction. But here they refer to mechanism, element, device, sometimes even processors been considered a nonce word. It's just in the consumer electronics or the software space, it's really hard to avoid these terms. So I would probably include these in, but if you have a lot of structural patents, you might want to just exclude them. And then with respect to strategic prosecution, in the mining activities, you might find some assets with some promising claims, but there just might be one element that's off or a couple here. And if you've open continuations out there, you can likely fix them with that. But if you don't have that, there is the possibility of broadening reissue if it's within 2 years of the issuance of the patent. It's just one area to be considered if you're like trying to remove a feature, that there is this recapture issue where essentially if that feature was added to the claim to get it allowed over the prior art, you can't remove it from the claim and reissue. So if that's the case, reissue is probably you can't use that avenue. Andy?
The slides aren't updating on my end.
Oh, sorry.
Thank you.
I'll refresh.
Yep, the slide updated there at the end, but that's all right. So then with respect to the some other strategic prosecution things to keep in mind is that when you're looking at a foreign prosecution, we've really tried to gear this towards US analysis, but some things to keep in mind is if you have a global portfolio and you're looking at assets in Europe, you're not going to be able to do the same things you can do in the US with your strategic prosecution. In Europe, they generally do not permit crossing embodiments or have intermediate generalization. What that means is, let's say you're trying to claim, you have a claim that you want to claim elements A, B, and C. In your description, you only describe A, B, and D in one reference or one embodiment, and then C, D, and E in another. You won't be able to take A and B from the one embodiment and C from the other and bring them together. Likewise, if you only ever describe A, B, and C and you just want to claim A and B, you may also be forced to always include A, B, and C. Again, that could be considered a generalization of an embodiment, and in Europe, it's much more difficult than what you may be able to do in the US. And then in China, they're extremely strict on literal support in your claim, so you may have to often use verbatim language from the way things were described in your specification to incorporate that exact same language in your claims. And the last side, it's just we wanted to provide an example of a claim chart to show you just briefly, like ultimately, what are you trying to do? You've identified an asset that you believe has high value. You try to then, you have to map out how is this claim infringed by the product of interest. And here's just a very bare bones example of what that would look like. You have an apparatus, and that would be like this printed circuit board that has elements A, B, and C. Element C has subcomponents C1 and C2. And as I've drawn out, like a very simple way of doing so is just you just demonstrate. Here's my apparatus, here's element A, here's element B, here's element C. It includes element C1 and C2. And that's ultimately what you're trying to do, is tell a story at the end of the day for how the evidence that you have aligns with all the limitations in the claim. And this is the most bare bones and simple example of a claim chart I could think of. But yeah, I'm sure everyone, we've seen the attendee list, is very savvy in this regard and knows what these are like. So that's it. If anyone has any questions, now's the time for us to open the floor.
Andy, I am not seeing any questions. I want to thank everyone for the patience with the tech glitches. I mean, as Jeff said, it's what happens in the remote work. I want to remind everyone that our next webinar is on November 18th, trademark rights based on common law and federal registration. And if you would kindly fill out the attendee form, we'd appreciate it. Jeff and Andy, thank you for a fantastic presentation. Do you have any final words?
Thank you, Anna.
Thank you very much. Thanks everyone for your attention.
Thanks, everybody.
All right, everyone, have a great afternoon. Thank you.